Hey everyone, Harry here. Fani Willis is staying the course, telling Judge McAfee, try all these 19 defendants together. All right, remember at the hearing last week, the first hearing in the case in front of Judge McAfee, and that involves Ken Chesebro and Sidney Powell's speedy trial motions, but more the motions to sever. Which he denied. He said, and this is the dynamic that is playing out in the whole case now, which is you need a good reason to sever. This is what Fani Willis is insisting on, whereas a speedy trial demand is automatic. And here's why it's really that specific contrast is front and center in the case. So in the hearing, McAfee makes clear that the two of them, Chesebro and Powell, will go together, and then that means they're the only ones whose trial has been set. So as of now, everybody's with them until there's a reason under the law for the other 17 or however many to be peeled off. And that's something that the burden's on the defendants to show. And to date, the arguments they've made don't really cut it. But McAfee, considering the prospect of a trial of 19 in October, so not just everyone together, but so soon with people screaming up and down, we don't have enough time to prepare, as Rudy Giuliani and Donald Trump already have said. He made it clear that he didn't think that was going to happen. Now, it's a little tricky because there needs to be, as I said, reasons to sever out. And the three main ones in the law, there, not enough time, as long as your due process rights are being respected, isn't a reason to be severed out. And we assume, since if it's constitutional for Chesebro and Powell to be tried, it would be constitutional for the rest. But still, McAfee says in court, I have more discretion than that, don't I? These three are non-exclusive. And you could see that he's really going toward a plan that would cleave off these two, so you wouldn't have a crazy situation where it's not only all 19, but it happens so quickly, and everyone is, completely protesting. So he said to the Fani Willis, to her office, the prosecutor there, look, this is how I'm leaning, but I'll give you a chance to persuade me. And yesterday, Fani Willis took her shot at persuading. And the first thing she said is, yep, let's do all 19 together. I'm staying the course. We don't have reasons yet to sever. And that's the sort of surface of the motion. But there's something going on, sort of reading between the lines. She's making a kind of more lawyerly finesse. Because what she's saying is none of the people who are moving to sever have given good reasons, nor have they consented to waive their speedy trial rights. What's that about? As is clear again from a close read of the motion, here's what she's saying. Remember, speedy trial, it's automatic. You ask for it, you get it. Severance isn't. So these people who are moving to sever, that she's saying they don't have any basis to sever, she's raising the specter, and it is in fact a worrisome one, where they sever out and then make the speedy trial motion. Pull a Chesebro, because Chesebro, as I indicated back then, he wasn't looking for a fast trial. He was looking for a solo trial. That's why he was so unhappy to have Sidney Powell now joined in the hip. So they're saying to the court, basically, they haven't even been required to waive their speedy trial rights. If you are going to sever them, our position is that, we go all together. We can do it. We've done it before. We can do it in this courtroom. If instead you're doing it different places, it's going to be really difficult, logistical nightmares, etc. We can do them all together. But if you entertain motions to sever, they should be conjoined with waiver of speedy trial, because otherwise you get a total mess of 2, 3, 4, 5 trials potentially kind of overlapping, and the gamesmanship of defendants who first moved to sever and then moved for speedy trial. So I think while her position on paper stays the same, we want all 19, and there's really no legal reason not to. The sort of wink and nod of the motion is, we know you're not going to do that, but before you sever, make them waive their speedy trial rights. That's a lawful thing to do. And then at least they still travel together. They nobody can any longer play that get out of the group free card by moving for a speedy trial. They have to, put up or shut up on the motion to sever. So, she with the motion, she stays to it, says, let's do all 19, God bless her. But I think there's a sophisticated recognition, and their papers have been pretty sophisticated that, okay, it's not going to happen. Okay, Judge McAfee, you're going to separate out, but let's try to hold the line at 2 or maybe 3 trials. Remember, we have this whole other group with who moved to go to federal court, 5 of them already, and Trump will join them. That seems like 3 natural cohorts. That's already kind of crazy for a 4-month trial with the same evidence being repeated 3 times. But for God's sakes, Judge, please, no more than that. And if we can keep it to 2, let's do that. And so something you need to do before really making this move is insist that they waive their speedy trial rights. So the ball's now back in McAfee's court. He doesn't have the motions from the 17, but he has them from some people. And if he cleaves them off, let's say Trump or Giuliani, because they say there's not enough time. Not a normal reason, but he doesn't. Now, in theory, the group travels with them, and he insists that they waive their speedy trial rights. So that'll be the next thing. In general, what we're seeing here is the fallout from Fani Willis as having brought not just a huge case against 19 people, but one that the evidence for all 19 is the same, because everyone has joined this sprawling RICO conspiracy. So, for instance, the first trial with Powell and Chesebro, there's only little bits that concern them, but the DA is going to put on the whole case over 4 months or more. Might not have a lot of jury appeal when people are sitting there saying, what's this got to do with the 2 people in the dock? But that's all the sort of fallout from bringing this RICO case in the first place, upsides and downsides. But for now, the DA is basically saying, okay, we know you're going to make at least 1 more group, maybe 2, but do what we can to hold it there, and in particular, force people to waive their speedy trial rights so they don't have that card to play. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.